Hello, and welcome to On Air with Akin Gump. I'm your host, Jose Garriga. The Committee on Foreign Investment in the United States, or CFIUS, is, according to the Treasury Department, an interagency committee authorized to review certain transactions involving foreign investment in the United States in order to determine the effect of such transactions on the national security of the United States. Created during the Ford administration, CFIUS reviews proposed investments in U.S. companies by a wide variety of countries, from Japan to Israel, the UK to South Korea. However, most recently, CFIUS's role in monitoring the national security implications of investment from China has been spotlighted by the Trump administration against the backdrop of the larger trade war between the U.S. and the PRC, even as efforts to reform CFIUS and make it more stringent are well underway. We have with us today Akin Gump International Trade Partners Tatman Savio, who works in the firm's Hong Kong office, and Christian Davis in Washington, D.C. They'll discuss the ongoing efforts to reform CFIUS, the projected impact on business in Asia and elsewhere, and what business people should know about these changes. Welcome to the podcast. Tatman, Christian, thank you for appearing on the show today. This is a major change in U.S. trade policy and regulation, so maybe we can start with a bit of background. Tatman, could you tell us, please, what prompted the need to reform CFIUS?
Thanks, Jose, and thanks for having me. I'm happy to dive into this, and I think that you introduced it quite well. As you said, the CFIUS regime was recently amended by the Foreign Investment Risk Review Modernization Act, otherwise known as FIRRMA, which is the law that was enacted in August of this year. And in order to understand how FIRRMA changed and will continue to change the CFIUS regime moving forward, I do think it's important to understand some fundamentals about CFIUS at the outset. As you described at high level, CFIUS is a U.S. government interagency committee chaired by the U.S. Department of Treasury that conducts national security reviews of what are known as covered transactions. Now, pre-FIRRMA, covered transaction was a defined term limited to mean any investment that could result in a non-U.S. person gaining the ability to control a U.S. business. And control has really been a central concept and part of that definition and CFIUS's jurisdiction. CFIUS has a great deal of discretion in evaluating covered transactions, and it also has a significant amount of authority in terms of the scope and results of its review. So let's just review quickly what it can do. It can initiate reviews of covered transactions and impose mitigation measures to address national security concerns that it may have, and recommend that the president block pending transactions or even order divestitures of completed transactions to the extent that they have not gone through a review process and gotten clearance from CFIUS. Historically, pre-FIRRMA, the CFIUS process was voluntary, but many companies decided to subject their transactions to review to avoid problems down the line in the event that CFIUS had national security concerns related to them at a later point. So with this baseline understanding of CFIUS as it has existed for the past many years, I think we can get into FIRRMA and specifically why it was passed. And the reason for the reform is quite simply China and China's efforts and success in gaining access to U.S. critical technologies and sensitive information in the United States through investments and acquisitions. CFIUS has made clear that its rules apply equally to all countries from which investments may originate. But that being said, for many months going back to 2017, the discussion about CFIUS reform has really centered around China and China's industrial policy known as Made in China 2025. That's focused on expanding its high-tech sectors and developing its advanced manufacturing base. And various stakeholders in the U.S. government, including the U.S. Congress, have been concerned about trends in Chinese investments and the way in which China has been able to use passive or minority investments or joint venture arrangements and other mechanisms to make successful investments in the U.S. economy and obtain critical technology or access to critical infrastructure or other sensitive information. So the concern is that China's development and dominance in this high technology area and a program subsidized by the state could affect U.S. leadership in areas related to national security. And that's where FIRRMA comes in to address this perceived national security threat by filling in the so-called gaps where China's acquisition of technology has been occurring.
Well, Christian, actually, thank you, Tatman. Could you, sort of from the Washington perspective, then, how exactly does FIRRMA reform the CFIUS process?
Sure, happy to discuss that. So, I mean, really, FIRRMA does a variety of different things, and it's quite an extensive bill and law that's now in effect. It changes CFIUS in ways that are entirely new, that just did not exist previously, but also puts into law some of the practices that CFIUS had developed over the years. The first thing to mention, and one of I think the two key changes, is that it expands the jurisdiction of CFIUS. And as Tatman mentioned previously, CFIUS only applied to covered transactions that were, resulted in a foreign person gaining the ability to control a U.S. business. Now that expands to 4 new categories. The first one being the purchase, lease, concession by or to a foreign person of U.S. real estate that is in a sensitive location near a U.S. government facility or is in or part of a U.S. port, including both maritime and airports. That is one change. So previously you had to have a U.S. business that a foreign person was going to gain control of. Now it applies to real estate transactions regardless of the existence of a business. Second, any change in rights of a foreign investor in an acquisition that they have made. This is after the actual acquisition is made, a change in rights that could lead to control, or a change in rights that could provide a covered non-controlling investment, which we'll discuss in a moment. So really, this kind of changes the idea of CFIUS being something that just happens at the time of the transaction, and really creates the potential CFIUS risk as an ongoing concern particularly in the context of a joint venture. Third is any investment that is designed to evade CFIUS jurisdiction, which is somewhat of a interesting point. The question of what is evading CFIUS jurisdiction as opposed to what is avoiding it. And that's something I think that we'll see over time in terms of how CFIUS looks at that. But really thinking about whether or not your transaction can be brought into CFIUS review, even though it doesn't meet the criteria because there's an evasion that has occurred. Lastly, in terms of expanded jurisdiction, is this concept of other investments that are non-controlling investments in U.S. businesses that are involved in critical infrastructure, critical technology, and sensitive personal data. Previously, it was only a control test and it applied to all businesses. Now these non-controlling investments that are in these certain sectors, critical infrastructure, critical technology, or have sensitive personal data, could be brought into CFIUS jurisdiction. The second major thing I think to discuss is mandatory reporting. Previously, as Tatman mentioned, we were only in a system where there was voluntary filings unless CFIUS actually directed you to file in a specific transaction. Under FIRRMA, there are mandatory filing requirements for foreign government-backed investments where a foreign government acquires a substantial interest in a U.S. business, and also in investments in certain critical technology companies that the statute gave CFIUS discretion in terms of defining what critical technologies companies would be included in the mandatory reporting requirement, which became part of this pilot program, which we'll discuss in a moment. So number one, expanded jurisdiction. Number two, mandatory reporting. I think those are probably the most important factors and changes that occurred as part of FIRRMA. The other ones I would mention, though, is that the timeline to CFIUS reviews has changed. It's generally been extended, and it's changed in a variety of different ways, but generally been extended. I think this really helps companies, though, in the long run, because it gives CFIUS more time to review cases in a single filing period, as opposed to forcing parties to withdraw and refile their application, which can lead to longer and longer reviews. So that is one change that we've seen so far as part of the bill is extended timelines. And another one are, instead of just one means of filing with CFIUS where you do a full review and a pretty extensive filing, There's now a short form process to get an expedited review with a short filing, and hopefully in less complex cases that will be used and effective in terms of getting clearance on an expedited basis. FIRRMA also introduces filing fees, which can be up to $300,000 per filing for a full written notice. FIRRMA also adds additional resources to CFIUS staff and really beefs up the staffing of CFIUS. And lastly, it creates a more robust process for identifying non-notified transactions. In other words, transactions that haven't been submitted to CFIUS, and monitors those and decides whether or not they present national security risks, and gives CFIUS the authority to bring those in and direct filings. CFIUS had this authority already, but in practice, it used this authority. But this change creates statutory direction to monitor non-notified transactions.
Thank you, Christian. You've mentioned something that I'd like to go into a bit. Pilot program. FIRRMA is going to go through a phased implementation. And so the pilot implementation program, the first bit of it, started last week. So which changes are immediately effective?
Sure. So as you mentioned, Jose, it really is a phased implementation, and there's really three phases. There are those changes that went into effect in August when the bill was passed, and then there are changes that went into effect this past weekend through a pilot program, and then the third phase and final phase will be the changes that are actually included in the final rules that are developed to fully implement FIRRMA, which will go through a notice and comment period, and we expect that to happen probably by the end of next summer or thereabout. So in terms of the actual pilot program, what does this do? Really, it does two things. One is that it expands CFIUS jurisdiction to capture certain non-controlling investments, and that went into effect on November 10th. And secondly, it creates mandatory reporting requirements that are also now in effect. And really, the key aspect of this is this only applies in a limited scope, and it applies to U.S. businesses that are quote-unquote pilot program U.S. businesses. The definition of a pilot program U.S. business is a U.S. business that produces, designs, tests, manufactures, fabricates, or develops a critical technology. And a critical technology is really a technology that is subject to export controls and is controlled for export on a variety of U.S. government lists. So if a U.S. business has one of these technologies and uses it in one of those ways, that's the first prong of the test. The second aspect of this is that business uses that technology in a targeted industry, or it designs that technology for a targeted industry. And what a targeted industry is are one of 27 different industry sectors that CFIUS has identified as part of this pilot program. And it really covers a really broad swath of the economy, which, and these sectors are linked up to the mid and 2025 plan that China has put forward and Tatman mentioned earlier. But it covers things such as aircraft manufacturing, petrochemical manufacturing, the defense industry in a variety of ways, batteries, biotechnology, nanotechnology, semiconductors, a lot of computer devices, chemical manufacturing. So it really covers, a lot of the economy and a lot of sectors. So if you go through and identify that your company qualifies as a U.S. pilot program U.S. business because it has this technology that it uses in a certain way, and it also uses that technology in one of these targeted industries, then your business is a pilot program U.S. business. And if a foreign person makes a controlling investment in that business, that would trigger mandatory reporting underneath the pilot program. Also, if there's a non-controlling investment, and this is the expanded jurisdiction, in a pilot program U.S. business, and that non-controlling investment results in access to material non-public technical information, any board rights with respect to the U.S. business, including observer rights, or any ability to direct how that company uses critical technology, then that would be now subject to CFIUS jurisdiction, even though it's not a controlling investment, and would be subject to mandatory reporting. So really now any controlling or non-controlling covered transaction in a pilot program business is subject to mandatory reporting. And really what that means is that 45 days in advance of closing that transaction, you must file with CFIUS to at the very least notify them of the transaction. You also have the option of doing a full CFIUS notice at that point. And you can either do a declaration, which is a short form filing, or as I mentioned, the full written notice. So you have that decision at that point. If you do not take that path, there are penalties that could apply, which go up to the value of the transaction. So there are significant penalties that could apply for not complying with the pilot program. And as I mentioned, that went into effect this past weekend, November 10th.
Thank you, Christian. A reminder to listeners that we're here today with Akin Gump, international trade partners Tatman, Savio, and Christian Davis discussing CFIUS, FIRRMA, and national security aspects of overseas investment in the United States. Now, Tatman, looking now at you're in Hong Kong, you're working with clients who might be looking at investment in the United States. So what does FIRRMA then mean in practical terms for these clients or businesses looking at state-bound investment?
Sure. Well, as Christian described, there are a lot of changes resulting from the new law and the pilot program, and we don't have final implementing regulations yet, so there will be more changes to come. It's important to note that the changes apply as a general matter at this point, not with respect to the particular nationality of the investor. And the changes will have both a practical and legal effect on companies that are seeking to pursue investments in not only U.S. companies, but more broadly, even non-U.S. companies that have operations in the United States. And one example of the practical changes that companies will face is the potential longer lead times. Pre-FIRRMA, the sequential review plus investigation process could take up to 90 days. And now post-FIRRMA, the review timeline may take up to 105 days. And this is important because in corporate transactions, timing can be everything, and it will be necessary for companies to build in these longer lead times for CFIUS approval. Now, it's worth noting, as Christian touched on, that even though the review timeline was shorter pre-FIRRMA, the committee was often unable to complete its reviews on a timely basis within those parameters, which meant that companies were often forced to withdraw their CFIUS notices and then refile them and start the review timeline all over again. So for that reason, it could be the case that even though the review period is theoretically longer, CFIUS may be able to conclude its reviews on a more timely and streamlined basis, especially given that it will now have additional resources resulting from the new filing fees and corresponding staffing increases. From a legal perspective, more transactions are now covered transactions, and it's now mandatory to submit a CFIUS notice with corresponding penalties if you do not. And I think this is really significant because pre-FIRRMA, many companies would analyze their transactions and make determinations not to file CFIUS notices, either because, one, they could make a determination on their own that a particular transaction didn't meet the definition of a covered transaction, often on the basis that the foreign investor didn't have control rights. Or two, companies would make a risk-based determination not to file a notice. And with FIRRMA, these two fundamentals of the approach to CFIUS review and analysis have changed. And so it's now the case that more transactions will be covered transactions and that parties may not have discretion as to whether or not they submit a filing. And so that brings us specifically to China and how that will impact Chinese investors. And as to the particular impact on China-based investors, this will of course have an impact focused on the Made in China 2025 sectors, especially in connection with other measures that the U.S. government is pursuing against China, including a new export control reform law and other recent enforcement actions that are focused on tightening up U.S. technology controls. So in effect, China's efforts to acquire U.S. technology by acquisition or other investment may become more challenging. But I wouldn't say that Chinese investments into the U.S. will be impossible. And in this regard, it's important to note that it has already become increasingly difficult for Chinese companies to invest in the United States, with several high-profile investments stalling or falling apart during CFIUS review, but with some others getting through. And at least now with FIRRMA, some of the rules and requirements are clearer and more transparent, which will allow companies to be smarter and more realistic about their transaction planning. And in addition to that, CFIUS review has been and remains case by case. In each transaction, CFIUS is looking at the potential threat posed by a particular investor, the vulnerability of the investment target, and the consequence of the transaction. And FIRRMA doesn't change that calculus. So there may be cases where CFIUS does not identify national security issues associated with a particular China-based transaction, or it sees one that can be mitigated somehow. And another point that I want to raise in this regard, to which I alluded a bit earlier, is the new export control restrictions. Concurrent with FIRRMA, Congress also passed a new export control law known as the Export Control Reform Act. And this law seeks to address concerns about foreign countries obtaining access to sensitive U.S. technology that currently isn't controlled, specifically what are called emerging and foundational technologies. And at one point, there was discussion about the new export control requirement becoming a part of the CFIUS process and a part of FIRRMA. And many people fought back against this concept because they wanted to keep the CFIUS regime separate from the export control regime. And with the parallel passage of FIRRMA and the new Export Control Reform Act, that separation does remain, but the emerging and foundational technologies identified under the export control regime will be considered as critical technologies in the CFIUS regime. So that interplay is still there, and I think that interplay will continue to reinforce some of the concerns and export restrictions that are focused on China.
Thank you, Tatman. Let's pull back a bit. And beyond China, what other overseas investment might immediately or perhaps in the longer term feel the impact of the FIRRMA reform?
Happy to answer that, Jose. I think, just thinking about this generally, I mean, and I think that the pilot program is a good example of this. The way that it was implemented, it did not apply specifically to China. It applied to all countries. So even though that was the intended goal of FIRRMA, was to really address risk associated with China, the way the law actually goes into effect is that it applies to all countries. So with respect to how it really impacts overseas investment, all investment will have to go through this expanded jurisdiction and mandatory reporting requirements, at least underneath the pilot program. We'll see how it shakes out underneath the final rules. And as a result of that, it really results in increased diligence requirements for any inbound investment into the U.S. Because again, you have civil penalties that could apply to your investment if you do not make a filing in advance and it fits within the pilot program. So at the very least, you have to do that diligence to determine whether or not your transaction is caught underneath the pilot program and potentially under the full FIRRMA requirements that go into effect at a later date. Secondly, if you are caught under the expanded jurisdiction and mandatory reporting, then you'll have another regulatory hurdle that you must go through as a part of your deal process, which can impact the timing of your transaction and needs to be factored into the deal. And third, and I think this mainly applies in the China context, but could also apply outside of that, there's going to be a small set of transactions that will go through the process and CFIUS will actually have objections to. And so there likely will be more deals that are actually blocked by CFIUS as a result of this, because that wider net has been cast by CFIUS to force more deals through. So we'll likely see additional transactions that are caught up, even though, as Tatman mentioned, really the overall analysis and criteria of identifying national security risk has not changed as a result of FIRRMA.
I think you all have done a great job of sketching out what it is that CFIUS and FIRRMA now are intended to do. I guess my question at this point is, will the CFIUS process, once fully reformed, once FIRRMA is fully implemented, will it achieve the stated goals? And if not, why not?
In answering that question, I think hit the nail on the head a bit there, Jose. It's a bit too early to tell exactly how this is shaking out so far. We don't know exactly how, for instance, CFIUS will respond to the increased filings that will come as a result of mandatory reporting requirements, for instance, underneath the pilot program. We also don't know yet the full scope of how CFIUS will draft the regulations, which will have a big impact on how broad the expanded jurisdiction actually applies to transactions and how broad the mandatory reporting requirements are. So that being said, that's still out there. But I think at the end of the day, the real question will be, I think it's likely that the national security issues will be addressed through this, or many of them will be addressed in that CFIUS will be able to get insight into more transactions as a result of FIRRMA. But I think the real question is whether at the end of the day, FIRRMA results in less foreign direct investment in the U.S. that is actually beneficial to the U.S., whether it really discourages folks from foreign investors from investing in the U.S., which was not the intended goal of FIRRMA.
That's a good point. Well, to close then, both of you have covered a lot of great material here. So let's see if we can crystallize this a bit. What are a few takeaways that you can offer listeners who might be looking to invest in the United States or to seek investment from overseas? And I'll add a little, maybe a nudge towards one possible answer in that respect is, which questions regarding the scope and specifics of this process remain unanswered? What lacunae are out there that people just don't even know can apply to this ongoing process of reform?
Well, I think that Christian touched on some of the unknowns still. We're still many months away from the deadline by which CFIUS must publish its final implementing regulations. And we expect that CFIUS will take the experience of the pilot program, evaluate it, and maybe incorporating as well as adding to the current interim regulations based on the reviews that it has done up until that point. So more remains to be developed in that regard. There are certain things that are clear at this juncture, which is that there will be mandatory filing requirements and expanded definitions for what is a covered transaction. And it will be really important for companies to do good, solid, comprehensive due diligence on their investment deals, both with respect to the investor, really going up the chain of beneficial ownership and identifying whether there's a foreign government-controlled entity at the helm, because there may be mandatory requirements depending upon the interests of a foreign government-controlled entity in a transaction, as well as with respect to the investment target and looking at that target and doing diligence to determine whether it is dealing in critical technology, because that can also subject the transaction to mandatory requirements. So it will be really important to do good, solid, well-rounded due diligence on all aspects of the transaction. I think that the other thing to look to in terms of future trajectory as we await the implementing regulations is what else is going on from a geopolitical economic standpoint vis-a-vis China. It would be a mistake to view FIRRMA in isolation on its own. It's really necessary to view it in relation to the export control reform law that I mentioned earlier, as well as the broader U.S.-China trade war, which has at its root as well concerns about IP theft and Made in China 2025 industrial policy. CFIUS is a legal regime. It is a regulatory process. But as we've seen in prior transactions, and we don't expect this to change, it can become very politicized. And for this reason, it's important to have clear transaction planning and strategy, which can include not only a legal strategy, but also a public policy one and a public relations one. That's something that we've seen historically, and we don't see that changing in the future, and perhaps it will become even more important. And the last thing that I would note with respect to some takeaways to offer listeners, and Jose, this also goes back to your point as to what should people be looking for. The U.S. government will have what's called a notice and comment period with respect to the regulations that it's developing. So it will conduct and solicit feedback from industry and formulating regulations, both with respect to FIRRMA and the new export control law. And so with respect to that upcoming process, we're encouraging and will continue to encourage companies to participate in the process to ensure that CFIUS has the benefit of their input.
Thank you, Tatman. Christian, what do you have for listeners that might be a couple points that they'd want to take away and think about regarding CFIUS and the FIRRMA process?
I would generally just reiterate the points that Tatman mentioned, with a specific focus on a couple things. One is, under the pilot program, I think it's become increasingly important to identify whether or not you have export control technology that could qualify as critical technology. Many companies, particularly earlier stage companies, have not done that analysis. And that can be an issue that will pop up in the deal process, and companies will not be prepared for that. And we've seen that happen in multiple examples already underneath the pilot program. In terms of focusing on the full implementation, I think specifically the points that I think are most interesting to see how they play out. One is understanding the full and true scope of the real estate provision and how that will be crystallized in the final regulations, because it could capture a broad swath of real estate, or it could be very focused. And I think that remains to be seen in terms of how broad that will be. Secondly, non-controlling investments in companies involved in critical infrastructure. The statute dictates that critical infrastructure be defined somewhat narrowly for purposes of this test. But I think others think that CFIUS will try to expand it broadly, and seeing where that balance is and what critical infrastructure is captured in the non-controlling investment provision will be something that will be important to watch. Lastly, the mandatory reporting requirement for foreign government investors. The term substantial interest is largely undefined at this point, and understanding what really constitutes a substantial interest by a foreign government in a U.S. business and that triggers mandatory reporting will have a big impact on the number of cases and transactions that are forced into the mandatory reporting process. Those are the three things that I'd be really watching with respect to the notice and comment period. And as I mentioned before, I think we're expecting to see a final rule, by the end of next summer, most likely, and a proposed rule before then.
Thank you. Thank you, Christian. Listeners, you've been listening to Akin Gump International Trade Partners, Tatman Savio in Hong Kong, and Christian Davis here in Washington, D.C. Thanks to you both. That was a great overview and analysis of a really significant change in the investment environment in international trade policy from the United States. And thank you, listeners, for your time and attention. Please make sure to subscribe to On Air with Akin Gump at your favorite podcast provider to ensure you do not miss an episode. We're on, among others, iTunes, Google Play, and Spotify. To learn more about Akin Gump and the firm's work in and thinking on international trade matters, look for international trade on the experience or insights and news sections on akingump.com. Until next time. On Air with Akin Gump is presented by Akin Gump and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.